Thanks for stopping by the channel. Make sure you hit the subscribe button, and once you've done that, check out the bell icon and make sure you get notifications for my content. So today we're going to talk a little bit about, should we say, the concept or the idea of the state of Minnesota being able to put you in a camp. Right. Because we're still dealing with the coup, right? We're still dealing with the coup. Over a year after the governor locked us down, we're still dealing with the coup. And make no mistake, it hasn't gotten much better in the eyes of the governor. And as recent reports shows, we have continued to mask up Minnesota. We've continued to social distance. We've continued to have limitations on our size of gatherings in public and private. We've continued to have expansion of the availability of the vaccine for people who want to take it. We have had massive strides in people reaching some form of natural herd type immunity. The numbers that we have seen as far as deaths have been greatly lower than what was originally estimated by the modeling plan that the governor trusted to 20-year-olds to put together. Now, there are a lot of genius 20-year-olds out there, okay? Plenty of smart people, a lot of people under the age of 20 that are incredibly intelligent. But the governor trusted a couple of 20-year-olds from the University of Minnesota to come up with this modeling plan for how many people were going to die, and we were expecting 70,000 or more, remember? And I've mentioned this before, oftentimes with derision, because it deserves derision. We bought an entire cooling building, a refrigerator, if you will, to serve as a morgue for all of the dead people that we were going to see in Minnesota, because I guess we were going to see people dying in the streets from the coup. And, you know, thank God, fortunately that didn't happen. The coup is real and it can kill people. But by and large, we haven't suffered the massive amount of deaths that we were told we were going to suffer, even with a lockdown. Keep that in mind. Lockdowns and stringent protocols against small businesses in Minnesota were going to result in even an incredibly high numbers of dead Minnesotans. And without it, we were gonna have astronomically high numbers, like world-shattering, world-ending numbers, and that never happened. But I said I was going to talk about the state of Minnesota putting you in a camp. Well, you're like, okay, there's TC being a radical conspiracy theorist again. So if you remember, a few months ago, I did a video about New York and their incessant need to try and come up with a regulation to pass into law that would allow them to incarcerate their citizens for medical emergencies, for pandemic emergencies, if they fail to follow guidelines. Well, I want to tell you, ladies and gentlemen, for once we are ahead of New York. So as hard as New York's been fighting for that, we the people of the state of Marxisota, the people's state of Marxisota, we have finally gotten ahead of New York on this. Okay, you ready? Here we go. Minnesota State Statute 12.39, individual treatment notice, refusal, consequence. Subdivision 1, refusal of treatment. Now, watch how they word this, okay? Notwithstanding laws, rules, or orders made or promulgated in response to a national security emergency or peacetime emergency, individuals have a fundamental right to refuse medical treatment, testing, physical or mental examination, vaccination, participation in experimental procedures and protocols, collection of specimens, and preventative treatment programs. You have a fundamental right to refuse all of those things, according to the state law of Minnesota. And this is codified, people. This isn't an executive order. This is codified. You have a right to refuse treatment, medical testing, physical or mental examination, vaccinations, participation in experimental procedures and protocols, and collection of specimens and preventative treatment programs. You can refuse that. So once again, the governor considers his mask mandate a preventative treatment program for all intents and purposes. He considers it a treatment program because it's preventative. It prevents you from spreading it. It prevents you from getting it, right? Well, according to the state law, you can refuse that. But he's made it a crime to refuse. Now, what about this? Now, you have to pay very close attention to this line, right? Or to these following lines. Okay, here we go. An individual who has been directed by the Commissioner of Health, Jane Malcolm, to submit to medical procedures and protocols because the individual is infected with or reasonably believed by the Commissioner of Health to be infected with or exposed to a toxic agent that can be transferred to another individual or a communicable disease, and the agent or communicable disease is the basis for which the national security emergency or peacetime emergency was declared, and who refuses to submit to them may be ordered by the commissioner to be placed in isolation or quarantine according to the parameters set forth in sections 144.419 and 144.4195. Subdivision 2 says, information given. Before performing examinations, testing, treatment, or vaccination of an individual under Subdivision 1, a healthy care provider shall notify the individual of the right to refuse the examination, testing, treatment, or vaccination, and the consequences, including isolation or quarantine upon refusal. Now, I want you to think about this. This first half of Subdivision 1 says you have the right to refuse all of these things. And then down here in Subdivision 2, it says you have to be notified that you have the right to refuse. But then they hang consequences over your head. So what are the consequences that are hanging over your head? This is 144.419, isolation and quarantine of persons. Definitions. For the purpose of sections, yada, 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 the following definitions apply. Bioterrorism, you can look this up. Communicable diseases, you can look it up. So here are some of the things. Viral hemorrhagic fevers. So, well, let's read this part. Communicable disease means a disease that can be transmitted person to person and for which isolation or quarantine is an effective control strategy, including viral hemorrhagic fever, severe acute respiratory syndromes, influenza that can cause a pandemic, a disease caused by bioterrorism, a new or novel or previously controlled or eradicated infectious agent or biological toxin, or any communicable disease included in the list of quarantinable communicable diseases is authorized by sections 361 subdivision B of the Public Health Services Act, United States Code, Title 42, Section 264, subdivision B. Communicable diseases excludes a disease that is directly transmitted as defined under sections yada, 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 right? Isolation means separation during the period of communicability of a person infected with a communicable disease in a place and under conditions so as to prevent direct or indirect transmission of an infectious agent to others. Quarantine means restrictions during a period of communicability of activities or travel of an otherwise healthy person who likely has been exposed to a communicable disease to prevent diseases transmissions during the period of communicability in the event the person is infected. This is where it starts to get very interesting. General requirements. The Commissioner of Health or any person acting under the Commissioner's authority shall comply with the paragraphs B to H when isolating a quarantined individual or group of individuals. Isolation and quarantine must be the least restrictive means necessary to prevent the spread of a communicable or potentially communicable disease to others and may include, but are not limited to, confinement to private homes or other private or public premises. Okay, that's where we got our justification, right, for the lockdowns. for our stay-at-home orders. It's in Minnesota law, right? But notice it could be in private or public premises. So if they deem that your home's not the right place for you to be, they could come take you away under this law. Isolated individuals must be confined separately from quarantined individuals. The health status of isolated and quarantined individuals must be monitored regularly to determine if they require continued isolation or quarantine. To adequately address emergency health situations, isolated and quarantined individuals shall be given a reliable means to communicate 24 hours a day with health officials and to summon emergency health services. You notice how they're wording this. There is this expectation that this could mean, this is in our law, people. Your law states that your government can come and take you away if somebody from the Commissioner of Health or one of their appointees, they can just come take you away. Oh, you've got the COOF. You've got COOF 14. We can come take you away. Well, how do you know? Well, we don't know, but we're going to make sure you don't have it. So, and we're not going to let you stay in your house because we don't think we can keep you safely in your house. So we're going to take you to a facility. Now, isolated and quarantined individuals must be immediately released when they pose no known risk of transmitting a communicable or potentially communicable disease to others. The needs of a person isolated and quarantined shall be addressed in a systematic and competent fashion, including but not limited to providing adequate food, clothing, shelter, means of communication between those in isolation or quarantine and those outside these settings, medication, and competent medical care. Premises used for isolation and quarantine shall be maintained in a safe and hygienic manner and be designed to minimize the likelihood of further transmission of infection or other harms to persons isolated in quarantine. The entire premise of this law is not that you have to stay home. It's if we've determined that you are in need of being isolated or quarantined, we have the authority under the state law, whether you like it or not, to come take you away. And there's nothing you can do under law to do about it. So subdivision 4 is very interesting. Any person who is isolated or quarantined according to this section and section 144.4195 has a fundamental right to refuse medical treatment, testing, physical or mental examination, vaccination, participation in experimental, and yada, yada. We went over this before. This is you have a right to refuse, but we're going to punish you for it. This is in Minnesota law, people, in law. And here's the other thing. Restricted entry, okay? So let's say they decide to order you to isolate at home. So if you're isolated at home, what's that mean? That means no one can have contact with you, right? So what are the odds they're going to really let people isolate at home as much as they, I mean, it happened this go around with the COOF, but what's their plan here? No person other than a person authorized by the Commissioner of Health or authorized by any person acting under the Commissioner's authority shall enter an isolation or quarantine area if by reason of an authorized entry into an isolation or quarantine area, a person poses a danger to public health. The person may be subject to isolation or quarantine according to this section and section 144.4195. A family member or healthcare agent of a person isolated or quarantined has a right to choose to enter into an isolation or quarantine area. The Commissioner of Health must permit the family member or healthcare agent entry into the isolation or quarantine area if the family member or healthcare agent signs a consent form stating that the family member or healthcare agent has been informed of the potential health risk, isolation and quarantine guidelines, and the consequences of entering the area. In other words, you enter the area, you ain't getting out. The family member or healthcare agent may not hold the Department of Health, the Commissioner of Health, or the state responsible for any consequences of entering the isolation or quarantine area. If by reason of entry in isolation or quarantine area under this paragraph, a person poses a danger to public health, the person may be subject to isolation or quarantine according to this section. We're going to take you away, and we might let your family come visit you, but once they're there, they're not leaving either. This is in your laws, Minnesota. These are camps. And it goes on, and there's due process. I mean, it's some of the listen, ex parte order for isolation or quarantine. Before isolating and quarantining a person or group of persons, the Commissioner of Health shall obtain a written ex parte order authorizing the isolation or quarantine from the District Court of Ramsey County. So you live in Fillmore County, do you? Well, we've decided that your area should be under quarantine and isolation. And not only should you be under quarantine and isolation, we're going to round you up and put you on a football field in neat white little medical looking tents. But we're not going to come down to your county to do this in court. We're going to do this in the District Court of Ramsey County because they don't know you. They know us. And this is our jurisdiction. So we're going to use the District Court of Ramsey County to do this. Instead of taking it to a local judge, we're going to take it to a judge that's out of touch with your community. Now, the county where the person or group of persons is located, or a county adjoining the county where the person or persons is located. They're never going to bring it to Fillmore County. They're never going to bring it to Mower County. They're never going to bring it to Freeborn County. They're never going to take it outside of Ramsey County. And we've seen that time and time again with the cases of the civil suits being filed against people like Lorvina McFarquhar and Lisa Hansen and Lisa Monet and Jane Moss. All of that was done, for the most part, or a good portion of it was done in Ramsey County, outside of the counties where the people who they were charging or suing lived. The court shall grant the order upon a finding that probable cause exists to believe isolation or quarantine is warranted to protect the public health. The evidence or testimony is in support of an application may be made or taken by telephone, facsimile transmission, video equipment, or other electronic communication. You don't even have to present real witnesses. It could be an email. That's what it says, or other electronic communications. What's email stand for? Electronic mail. The order must state the specific facts, yada, yada, yada. If it is impractical to provide individual orders to a group of persons isolated or quarantined, one order shall suffice to isolate or quarantine a group of persons believed to have been commonly infected with or exposed to a communicable disease. A copy of the order and notice shall be posted in a conspicuous place. We don't even have to give you it. We can just post it someplace where it can be easily seen. And if you don't see it, that's not our problem. There's this subdivision 2, temporary hold upon commissioner's directive. Notwithstanding subdivision 1, the commissioner of health may by directive isolate or quarantine a person or group of persons without first obtaining a written ex parte order from the court if a delay in isolating or quarantining the person or group of persons would significantly jeopardize the commissioner of health's ability to prevent or limit transmission of a communicable or potentially communicable life-threatening disease to others. The directive shall specify the known period of incubation or of incubation or communicability, or the estimated period under the commissioner's best medical judgment when the disease is unknown. The directive remains in effect for the period specified unless amended by the commissioner or superseded by a court order. The commissioner must provide the person or group of persons subject to temporary hold with notice that the person has a right to request a court hearing under this section and the right to be represented by counsel during a proceeding under this section. If it is impractical to provide individual notice to each person, yada, 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 conspicuous, yada, 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 immediately upon executing the directive and initiating the notice of the parties subject to it, the commissioner shall initiate the process to apply for a written ex parte order pursuant to subdivision 1 authorizing the isolation or quarantine. The court must rule within 24 hours of receipt of the application or sooner if practicable or necessary. If the person is under a temporary hold, the person may not be held in isolation or quarantine after the temporary hold expires unless the court issues an ex parte order under subdivision 1. If the court does not rule within 36 hours after the execution of the directive shall expire. Look, people, this is codified into Minnesota state law. They don't have to give you proof that you're sick. They don't have to give you proof that you've been exposed to anything. They don't even have to go to a court to get it done. You don't have to have committed a crime. All the health commissioner in the state of Minnesota has to do is say, oh, this is a public health emergency and you have been exposed to a communicable disease. This is an absolute must. We're coming to get you and we're sending X, Y, and Z to your house to take you away for your own good and for the good of the public health. And then when we can, we'll get a judge to see it. Now think about this. If a judge doesn't rule in favor of the health commissioner, then they can hold you for 36 hours. If the judge doesn't rule at all. If the judge rules against the health commissioner, then you can be released right away. And you have a right to refuse all of these things, but if you refuse all of this stuff, then you still can be hauled away. So you have no right to refuse in Minnesota. None. You don't have a right to refuse. If the health commissioner says, I'm ordering my underlings to go out around and order in every county and every town and every county that everybody in this county is going to be inoculated with a vaccine, you will take it. Oh, but you have the right to refuse, but we can also take you away. Do you understand that? You can be placed under house arrest, or you could be taken off to some confinement area somewhere, which, it has to be nice, for committing no crime. Well, you can refuse, but we could take you away. But I don't want to go. I'm refusing to go. Well, we're still going to take you away. And then you can appeal to the courts. Do you understand how terrifying this is? They don't even have to prove you're sick. They don't even have to prove you've been exposed. It just has to be a reasonable belief by the public health commissioner or one of their assigned agents. This is what tyranny looks like when it starts. And we all just close our eyes and fumble through the dark thinking, oh, that'll never happen here. It can happen. It's in our laws. People that you voted for this. People that you put in office voted for this. You think we're a republic still in the United States? You think that Minnesota is a democracy? You and I voted for people who voted for this. This should scare you. Once they've determined that you're sick, or once they determine that you're a risk to someone else, you have lost all your rights. Even if it says you have the right to refuse, you still get hauled away. Don't think it can't happen. It can. And don't think that we're out of the dark now, because they are not done using the COOF against us. What are you going to do about it, Minnesota? You need to demand that this gets repealed, and repealed real quick. Sadly, most of you are walking around with your eyes closed or your head stuck in the sand saying it could never happen here. And it could. Just wait until I get started on a vaccine passport. Until next time, wake up. Sic Semper Tyrannis.